easy to get trapped. So we have Isabel Cumming, who was a special prosecutor. She knows all about frauds and scams, and really is an amazing speaker too. So we've had her before on preventing ID theft. She's very entertaining and a great storyteller. So I think y'all will enjoy that session as well. And given the turnout today, I think we might need all 3 rooms, so I might need to adjust that. But again, you'll have an opportunity on the survey to say what other topics you're interested in doing. Some of the ones we've talked about are retirement saving and distribution, and that should happen in November. Buying the first home, maximize, so you see it's for all ages, not just people in wealth. We're doing maximize your credit score, and saving and investing for teens are some of the other topics we've talked about. But we're open to other things that you think this community needs to hear. So in the meantime, I'm going to turn it over to Gloria Della with Commission for Women.
Good morning. Thank you all for coming. This is an amazing turnout for our very first session. As she said, I also want to say that this is our first session in a year in which we turned 40 years old for the Commission for Women, so it's nice that we could stand this up in the year where we were celebrating our 40-year anniversary. Ms. Phipps, as she mentioned, is a pillar of the community. She has been doing wills for some time, and I have to say, I admire her for her zest and her zeal for her and passion for what she does, because the woman takes individual clients, if you can believe it. But anyway, she must know the law, and she stays abreast of the issues that relate to changes in law, because for her job, she has to be able to know the law and to relate it to the people she's talking to. And she does speak King's English. And I don't mean literally King's English, but she speaks English in a way that people can understand what it is that they need to know. She guides them through and assists them. But one thing she will always tell you, she's not a lawyer, and she can't interpret the law, and she cannot do policy. But she can tell you, as you know, in her profession, what it is that you need to know to be able to protect your assets and make sure that they go where you want them to go. Accompanying her today, but not as a speaker, we have brought in Jennifer Dill, who is a family law attorney. She is also one of our commissioners, which is why we begged her to do this, and she reluctantly agreed to do it. She is with the firm Ferranti and Dill law firm, and they are here in Southern Maryland and have been for 10 years. And she's going to answer questions that are general advice on legal issues that might relate to will at some point. So, without further ado, I would like to have Ms. Phipps come to the podium and begin her presentation.
Yes.
I always have to lower the mic. Now you can see me. Good morning, everybody. It's such a pleasure to be here and to see so many of you take time out of your Saturday morning to come and learn what will help you to protect your assets. I have passed out folders. I've passed out folders. There's a flyer in the front that tells you why you need a will.
Take out the box, okay, because people can't see it.
Now, everyone really needs a will. There are many things you can do with that will. You can specify who you want to receive your assets when you're no longer here. You can nominate a guardian for your minor children. Now, you know, a lot of us don't think about that. Young people don't think about that. And I'll be quite honest with you, when I was young, I have 4 children, I thought a will was for old people. But that's not right. All of us need a will, but young people that have small children really need a will because they need to appoint a guardian for those children and state their wishes. We live in such fast times, automobile accidents, all kinds of accidents, and we want to prepare for our children. We'd like to have a say in it if we're not going to be here. So that is so important. You name a personal representative. Now, a personal representative is a person that steps into your footsteps, technically, and marshals all of your assets, pays your bills, settles everything, and then distributes according to the way you have chosen. You want that person to be someone who is able to keep good records, who has sort of a business head so that they can think straight, and they will listen to an attorney when there are legal matters that have to be taken care of. So that takes some thought. A lot of us enjoy our church and our charities, and we want to make a donation in our will to them. You can do that in a will. That will not happen if you don't have a will. So you can make charitable bequests. You can create trust. You can make special provision for people that have helped you if you so choose. And the one thing that I hesitate to mention, but it exists, so you need to know it. You can exclude certain heirs. I don't recommend it, but you have that privilege if you do a will. And really, it provides for family harmony. A death is a very traumatic time in the family. And when the family has to come up with who's going to be the personal representative, who's going to do this, who's going to divide the property, it causes stress. And if you have spoken your wishes in a will, it makes it much easier for the family. So now you've really done all you can to try to help your family. So a will is very important. Now, I must tell you, there are certain things that a will does not control. So you have to think about this. A will does not control real estate that has joint names, or there are certain titlings of real estate. Tenants by the entireties is husband and wife. Tenants in common is with someone else, or husband and wife can do tenants in common. But if you're in tenants in common, you have an interest, a half and half. If there are two of you, if there are three of you, it's a third, and a third. Each has they're each his or her own undivided one interest in there. So you have to, a will can control that undivided interest of a tenant in common. But joint tenants, or joint tenants by rights of survivorship, is not controlled by a will. Insurance policies are not included in a will. We have had problems where wills have stated, I want so-and-so to receive my real estate. And 2 years later, that person deeds that real estate to someone else. And it's very difficult for people. They didn't change their will. It's very difficult for people to understand that that real estate is no longer controlled by that will. It's gone. The deed has superseded any content of that will. So when that person died, by operational law, it went according to deed. So be careful if you do anything like that when you're getting prepared. There are a couple things that I think that you ought to do about making your will. How many of you have seen on the internet and advertisements, get your will package, do your own will, all this? They advertise it all the time. Now, I'm going to be quite honest with you. I don't think that's the best way to do it. Have you ever told someone something and meant one thing and they understood it another way? Think about it. All of us have done that. I have seen that happen in wills. So I really urge you to make an appointment with an attorney and have him or her prepare a will for you. They have the ability to help you decipher what you're putting in that will so there will not be misinterpretation. You know, you're not going to be here to say, oh, that's not what I wanted, because this will takes over after your death. So I really urge you to think carefully about that. I've seen a lot of things happen, and I don't want it to happen to any of you. I'll give you one example. Many years ago, there was a lady who had an attorney prepare her will. And in those days, it's been a while back, there were people that had some insurance policies, and they used to have people that came around once a week or once a month to collect the premiums at any area. Remember? Okay. You know what I'm talking about. So you become friends with them because you see them quite often, and if you don't have a lot of family in, they become really good friends. She was discussing with this gentleman one day that she wanted to make a small change in her will, and she really didn't want to pay the money to have an attorney do it again. He said, okay, I can help you do that. So he retyped the will for her, typing what he thought her wishes were. And when she died, it didn't say what she wanted, and she was coherent until the day she died. The whole family was there, and thank goodness the whole family was in agreement, because it could have been a fiasco. She wanted her daughter to have the right to live in her house until her death, and then the remainder would go to all of her children. That's not what the will said. Now, we lucked out on that one because the family was in agreement. She had proclaimed up until her death what she wanted. So we were able to work it out so that the family joined in, and her wishes were carried out. But that's very unusual, because when someone dies, it sometimes brings out the worst in people. There's an old saying that money and death make strange bedfellows. Believe me, it's true. So you want to be sure you have your affairs in order so that you don't have those type of situations occur. Okay. Now, you're getting ready to make your will, and I know some of you do have wills already. Wills should be really reviewed at every 10 years, or when a major happening occurs in the family, a death, a marriage, a divorce, many things. They should be reviewed at that time. But if you don't have a will, and even if you do, you need to reevaluate. And I have a list of information on assets. Before you go to your attorney, you should sit down and take stock of everything you have. And it might amaze you to find out that you might have more than you think you have. So go over that and fill that in before you go to an attorney. It helps the attorney. It helps you. Things go faster, they go easier, and it just makes everything go better. Also have in here a letter of instructions, and please take note of this. A lot of people put their funeral arrangements in their will, and that's okay, but somebody else needs to know that. You should have somebody fully aware of your funeral arrangements, because they might not be able to get to your will right away. They should know what you wish for funeral and burial. In fact, a lot of people now do prepaid funeral arrangements, and that works as well. You need to make someone aware of your attorney, your accountant, your tax preparer, your investment counselor. Someone needs to know where to find the information about your assets. We have had estates where it's been very difficult to find just what assets this person had. We might have to wait till the following year when the 1099s come out to know where all the accounts are. Okay? So that's very difficult for a personal representative, a person that you put in charge, if they don't know where things are. They don't need to know before your death, unless you choose to advise them. But you need to have it written down so that they can find it. Your safe deposit box, if you have one. Even the location of marriage and birth certificates. So take stock when you get home, and take that information on assets and start to put things together so that you know what you really have. Now that we have everything ready to go to the attorney to do our will, there are a couple other things that you should talk with the attorney about. You want a will, make a list. For goodness sakes, make a list before you go, because it's just like going to the doctor. You have a couple things wrong, you get there, and then you forget one of them because you get a little nervous, and it's just human nature. You make the list. When you get there, you tell the attorney what you want. And then if you have questions, the attorney is there to assist you. But in addition to the will, you really should have an advanced medical director. Everybody should have an advanced medical director. It's part of your planning. And talk with the attorney about a financial power of attorney in case you're in an automobile accident and can't take care of your affairs, or you have a stroke or something and you can't take care of your affairs. You need to have someone ready to step in, someone you really trust, step in and take care of your affairs. Now, I've had this happen, and it's not the best situation. I will use a widow. Excuse me, gentlemen. We have more widows than we have widowers usually. But the widow comes in, and they have these joint bank accounts, and they go in the bank, and she will say to whomever she's working with, should I take his name off of this? And the advice they get is that yes, you need somebody else's name on there to pay your bills and do your things, take care of your affairs. Now, you know what happens? They set that account up as a joint account with rights of survivorship. So that widow dies, and whichever child or whomever she has put on there as her joint tenant with rights of survivorship receives that money by operation of law. Now that can, if a family is not getting along, that can cut the other children out of a bit of money. So you want to be really careful, and that's why I suggest you discuss with the attorney about having a power of attorney. Because that account can still be in your name, but the power of attorney will function to take care of your affairs. Now, you're going to ask me, what's it going to cost? Everybody says it's so expensive. In some cases, it can be. It depends on what you decide to do. if you have, in your will, if you have young children and you're gonna set up a lot of things, or you're gonna do this, or you need a special needs trust for disabled child or something, that's gonna cost you a little more than just a simple will. But those are the things that need the most attention. So you want to be sure you do pay to have that done correctly. So when you stop and think about it, it may cost you a little bit, but it is to protect you and your family. And like I said, once your death occurs, you're not here to say that wasn't what you wanted, so you want it done correctly. Then I hear this about the taxes. Oh, the taxes are going to be so bad. In the state of Maryland, there is an inheritance tax, but it only affects nieces, nephews, and friends. Children, grandchildren, stepchildren, parents, siblings, grandparents, there is no inheritance tax in the state of Maryland. You know, the inheritance tax is a right to give that to someone. There is a Maryland estate tax that is, if your assets exceed $2 million, as of January 1, 2016, then there is a Maryland estate tax that needs to be filed. And that's a right to give something. And then you hear the big one, the federal estate tax, and that's over $5 million now. So, if somebody questions taxes, they are really, as far as estates in the state of Maryland for the inheritance tax, you really have no tax unless they're nieces, nephews, friends, and you don't have a tax returns to file unless it's over $2 million. But those you would absolutely need an attorney or CPA. There's no, you absolutely would need them. And I have to mention trust, although I don't do anything with trust. Trust is a good tool in certain estates, but it is not an absolute for everyone. Everyone does not need a trust. And but you need to investigate with your attorney and before you do that. Just because somebody tells you you need a trust, you want to be sure. But everybody does need a will. Because even if you have a trust, there has to be a pour-over will that will take care of anything that the trust didn't cover. So that will be my discussion on trust, because that's not my ballywood. But I do have to make you aware of everything that's out there. That's part of my responsibility. Now I think we're ready maybe to take questions.
What about guardianship?
That can be established in a will.
Okay.
If you could.
I'm so sorry, yes.
What about guardianship?
What about guardianships is the question. Now, if you need to establish a guardianship, when you do your will, it will be set up. You will appoint your guardian, and then that person that's been appointed through the will go into circuit court and establish the guardianship.
Will they lose their rights of being a property manager?
The question is, will they lose their rights of being a property manager? That's a legal question. I can't answer that, I'm sorry. Jenna, you want?
So the question is, will they lose their rights? You mean the person who's giving up, who needs the guardian, correct?
Well.
Not the guardian themselves.
The guardian themselves, yes.
Okay, so the person acting as a guardian has the rights as a guardian to step in the place of the person who has the assets.
Okay.
So there, it's very similar to a power of attorney, except that the actual person loses their rights. With the power of attorney, you don't lose your individual right to manage your own affairs. A guardian is a different process where that person who needs the guardianship is determined to not be able to take care of their affairs themselves. A
Okay.
power of attorney doesn't require that. Anybody, every one of us in this room
Can be a
should
power.
have a power of attorney in the event we're unavailable, or maybe we just want somebody to assist us with our affairs, but we're capable. A guardianship means the person is not capable anymore, and a doctor has determined they're not able mentally or physically to manage their own affairs.
But what if they haven't been managing their affairs, but yet the
So that's
child uses the power of attorney, power of property, whatever attorney, and everything, and yet someone says to them in a courthouse, you need to get the guardianship.
So with the power of attorney, if I give somebody a power of attorney, I can take it back. And you no longer have authority to manage my affairs for me. See, with a guardianship, I wouldn't be able to do that. So you would go through a court process, and the court would say, okay, we agree with you. This person is not able to manage their affairs. You have to prove it. And you do that by the assistance
By
of
the
the
doctors.
doctor.
Yeah.
And then that person loses their power. They can't take that back.
The person himself
Or
that
the
you're
person
doing the
who is-
guardianship on?
The person with the assets that need to be managed
Okay.
can no longer exercise power over their own
But
affairs.
that's basically the same thing what the children named in the power or as trustees would
It's
be
not.
doing.
It's not if that person, because I'll give you an example. There are times when a person, Alzheimer's, for example.
Yeah, I'm sorry.
Sorry.
Yeah, you might
I
as well.
should be standing up. Sorry. So let's give an example of Alzheimer's.
Yeah.
So a person with Alzheimer's, sometimes they're with us
Mhm.
and sometimes they're not. They may have moments of lucidity.
Mhm.
In those moments, they may say, I don't want her doing it anymore. So I'm taking my power of attorney back and I'm going to give it to Miss Phipps here because she can handle my affairs. Well, the person is not capable of acting on their own best interests. So you go to the guardianship process and you show, while this person had the power of attorney, God love her, she's really not the appropriate person to be taking care of her affairs. The daughter should. Just an example. Does that make sense?
Well, it's sort of, but I'm in this situation with my mother on this,
Okay.
like this.
I can't
but-
get into
But
specifics.
I'm not gonna.
So
yeah.
if you find yourself in that situation, the best thing to do, just like if you have a medical issue, you go get an opinion, it's worth it to go find out what's wrong with your elbow.
That's
It's
why I
worth
came
it
to
to go
this
get a
meeting, is to
consultation.
find a representative or something that I can go get in.
Just go get a consultation.
One of the things I do need to say,
Mhm.
mostly in the Register of Wills office and the Orphans Court, we deal with minors. We're talking about adults. And that's strictly a circuit court issue and almost a separate issue,
Okay,
just to clarify.
okay.
Margaret, excuse me. Walk us through when someone dies. Do we physically go to your office to retrieve the will? What is the process?
Could you hold that question for just a minute until we finish? I would like to answer all the questions for getting prepared. Then you die. Then
We're the same age, Margaret. Let's put it off a little while.
we all want to do that. But yes, but please ask that question when I open it again.
This may be a will or a legal one. You've written your will, but let's say you wanted to disperse some of your assets before you die. At one time, it was like $10,000 per person per year, per calendar year. What is it?
13.
I'm not allowed to give tax advice.
Okay.
I'm an attorney, so that's where your CPA, your accountant comes in. So I don't like to quote, but my understanding is it's 13,000. And what the reason that we have that law is just for that reason, so you could give away some of your assets prior to passing because we're so worried about those inheritance taxes.
Or spending down for other reasons.
Spending down for other reasons, or we just want to, manage our affairs ahead of time.
Or help somebody out now.
Yeah, you want to be mindful that you don't, when you are gifting, that you don't overdo it.
That's a gift tax issue, and I
Right.
believe that anything above 14,000 from one individual to another is something.
Well, that's what I'm saying, because as far as if you give, you can choose to give, let's say you have 6 kids, you can choose to give 4 of them some and not the
You can
others.
give anybody.
But whatever, or you can give anybody.
Anybody, without paying gift back.
We just went through this with my parents. My parents were giving money to help our son with graduate school. And so they went to their lawyer and they said, okay, we want it, how much can we give? And it was 14,000. They live in North Carolina, but it was 14,000. But the attorney said, but you put money in their bank accounts every month. You give them some spending money. And you want to hold some money to give them some, maybe some cash at Christmas. All of those are add up to that 14,000. And so you've got to think about all the money in a year that you've given somebody, and it has to be 14,000. And that's with my parents, who have all joint bank accounts. Like, if they had separate accounts, they could each get 14,000. But everything is together. So they didn't think about, that money, the spending money they give once a month, or the check at Christmas, or their birthday. All of that has to be 14,000. So that's where it's really helpful to have an account for somebody.
We're gonna take one more question from this lady here. Well, we'll take 2. Then you can move to, back to your presentation.
Okay.
So you have,
Well, my question was, so you have to have 2 separate accounts
If they
versus
each wanted to give 14,000, I could train. But if they, my parents, everything's
Joint,
joint,
so
they
it
could
counts
only
as one.
give 14,000.
interesting.
In totality.
Those are really items that should be discussed with the CPA.
Okay.
I'm not a CPA, but I'm reading from the IRS.gov site. You can ask the librarian, we can give you information about where to find these things too. And it does talk about, there's an FAQ, what if my spouse and I want to give away property that we own together? You are each entitled to the annual amount of the gift. Together you can give, well, this was different dates, so 22,000 for 2002, 24,000 for the current 28,000 on or after January 1st, 2013, including 2014, 15, and 16. So does it say it has to be separate?
Yeah, so yours where it said,
They live in North Carolina.
oh, so maybe it's with the state.
I don't know.
So I think what that shows us, ladies and gentlemen, because we're here for Financial Literacy Forum, what this shows you is there are a lot of issues out there when we are getting ready to do our will and managing our affairs. So it's important to get information from people who know what they're talking about.
we have a question over here. Actually, then we have one from
It's a 2-part question. First, Scripture had mentioned taxes on the Maryland state level and the federal state level. What about the county level?
No county.
Okay.
This is state.
Okay.
Yeah, I actually am a state employee. I'm not, the county has to give me a spot to have an office to serve the citizens of Calvert County. But I'm a state official. Well, I'm not an official, I'm just. And then, but it's state, so the county doesn't have to.
you follow.
What is the difference between a will and a revocable living will? What is the difference for concern of property?
What is the difference between a will and a revocable living will?
In regards to property?
A revocable living will, as to my knowledge, is a living will is your health care. It's not a will taking care of your property. Yeah.
So you may be confusing revocable with trust. And people confuse a living will as a similar document to our last will and testament.
Yes.
They're completely different. A living will, like Ms. Phipps had said, has to do with making your medical decisions for you. When we hear the words revocable, irrevocable, most likely what we're thinking about are trusts.
Sir, then we'll take the lady in the back after you.
Okay. 3 questions, but they're simple ones. The representative that you stated in your will, does that person have to be a resident of Maryland?
They do not, but if they are not a resident of Maryland, they need a resident agent, someone who lives in Maryland, because we cannot subpoena them if they don't do their due diligence, and we can subpoena the resident agent.
Okay. On the power of attorney, can you have a primary and a secondary listed in case the primary passes away?
I think, I'm not a legal expert on that, but everything should have
What was
a.
the question?
Oh, I'm so sorry. Repeat the question.
For your power of attorney, can you list a primary and a secondary in case the primary passes away?
On the power of attorney, do you list a primary and a secondary? You should list a primary, a secondary, and maybe a third person on everything.
And just to clarify, there's a difference between having somebody step in the event the person is unavailable or unable or unwilling, as opposed to co. So be careful when you're discussing this. When you appoint two people to be decision makers or to act on your behalf, it could be problematic. That's a situation to discuss with an attorney to decide if that's the best way to do it. But as Ms. Phipps said, absolutely, you want to have backups to your backup.
The last question I have
May I add to that? For the sake of ease and swiftness through an estate, I really recommend you only appoint one. Co-PRs, 2 or 3 can create chaos. Because they all have to agree, they all have to sign, because when they become a personal representative, they become one entity. The banks won't let you put the 2 names on there or 3 names. So it's really for convenience purposes.
I was thinking more along the lines of if my wife and my power of attorney, we were both killed in an auto accident, if I have my daughter as a secondary,
That's perfect.
Keep in mind, though, that your power of attorney extinguishes upon your death. Your power of attorney is no longer the tool that's used to manage your affairs. Last question, lady in the back.
Well, I had a similar question. I think we're going to take the power of attorney with a personal representative.
Can you speak up? We can't hear you.
I had a similar question about the power of attorney. Ms. Phipps, you were mentioning a widow with a joint account with a right of survivorship should have power of attorney rather than right of survivorship.
Now, if I may, I didn't say you should have it. I wanted to indicate what could happen if you had it with joint tenants with rights of survivorship. It legally goes to that one person. Whereas if you wanted to have control of it so it could go to everybody, a power of attorney could control that.
So what happens if you have a bank account? Ms. Phipps and I get a bank account together, and we hold it with the right of survivorship. It goes outside of the will. Ms. Phipps gets all my money.
And I just
my
walk
family
away.
won't get it. So similarly, if you have a child, put on your bank account and put on it in a way where they're the co-owner, they have the right to get all, it's called the right of survivorship in the bank account, it's going to pass outside of the will. So while you think you're just making it easier to have your child help you manage your affairs, once you pass, and this is what we're talking about, the first step, it may be helpful, but it's going to be hurtful come your death. So a power of attorney will let them do the same thing that they could do if they were on the bank account, but keep them off of, keep it in the estate.
Right, I think I misspoke instead of right of survivorship, I think it was a joint account. And the power of attorney can only come into play while the person is alive, as I understand it. So what happens when that person dies if they just have an account in their name and it's not in the will? The power of attorney actually ceases at death. So then what happens?
A power of attorney ceases at death, that's correct. The question is asked if what happens if she has a power of attorney and this account is just in her name. The power of attorney does cease at death. And all of your assets then go into an estate, and that's what we're going to talk about next. That goes in the estate. It's a part of your overall estate and is distributed according to your will.
So I think this is a nice segue to go back to
Yes.
your presentation.
All right, now, we've done all we can to get prepared, and then after death occurs. You had a question, Mark.
I did. What's the process after the death? Do we physically come to your office to retrieve the will? What do we do?
Okay. The question is, what happens after death? Do we physically come into the office to retrieve the will, or what happens?
Can I just ask you, what office are you talking about?
I'm talking about the Register of
I
Wills
know,
office.
but for those
Excuse
folks
me.
who might not.
Register wills,
Wills
yes.
office.
Yes, I only speak to that, so please, don't mistake any other office. We're the Register of
Register
Wills.
Wills office.
All right, you or your attorney have filed your will with us, which we accept for safekeeping for a cost of $5, put it in our vault, and it remains there until it's needed, your death. Or you decide you want to change it and you come in and you can take it out. So your will is safely in my vault. Your family comes in to me with a death certificate. That gives me the authority to open that will, and I keep it. That will never leaves there. I make copies for your family to take to the attorney to help open your estate. And that's when we begin the process.
Can anyone in my family, does it have to be somebody designated to get my will from the registrar's office?
The question is,
Anyone having the death certificate has the right to.
the question is, has to be anybody specified to come in and get that, or just the death certificate? Believe it or not, if someone has a death certificate, even if they aren't a child or a member of the family, I can pull that will,
Thank you.
as long as I have a death certificate. But like I say, the original never leaves my office. Now, if an attorney decides to keep that will at his or her office after they have made it, or if you take it home with you, the original will, which I don't really recommend because there's always a danger of fire, even in fire boxes that you have. It is the duty of the custodian of that will to bring it to the Register of Wills office as soon as it's convenient that they can get it there to secure it. It's not passed around because it's too easy for someone to destroy it. And it is a criminal offense to destroy a will. So be careful. Now, you have designated a personal representative, and I hope you have told them what you've done, which would be a good idea. That personal representative now has a responsibility to get the paperwork prepared and file with the Register of Wills. There is so that your will can be probated. Now, you're going to ask me, what is probate? And it's actually a legal proving of the will to be a genuine will. And we have the authority to do that. If it's witnessed properly in Maryland, we require 2 witnesses. And we have an attestation clause, we call it, that you declare that you're in the presence of the person making the will, and they declare that you are there with them. You do not have to see what's in that will. You just say you saw them sign it. And attorneys, as they make wills, are very careful with this. And they're very particular about being sure that attestation clause is there, because then we can accept it with no further ado. Now, if you just have 2 signatures on it and no attestation clause, the witnesses have to come forward to say that they saw them sign that will. So, there's another reason to have an attorney do your will, to be sure it's done properly. And it saves work for your personal representative. Once the papers are prepared, usually a personal representative, it's usually the personal representative that comes to the office with the death certificate. Other times, other things happen, but we give them a copy of the will. They go to an attorney to help them prepare the papers that they present to us. We have to set a bond if it's over $50,000. Assets in the estate are over $50,000. We have to set a bond because the personal representative needs to be bonded to be sure that they handle things properly, pay the bills, and whatnot. And it's all everything gets filed, We appoint them. You'll see the notice in the newspaper. Have you seen the notices in the newspaper? And then the personal representative begins their work. And we move on. In 3 months after the date of appointment, we want an inventory filed. And that is a listing of all assets that were owned individually by the decedent. Joint assets are reported on an information report, but they are not in the estate. That is one of the most difficult things for some personal representatives to understand. Anything that is jointly owned does not come in the estate. Tenants in common undivided interest comes into the estate, and any other individually owned vehicles, everything is a part of the estate. Investment accounts that just in your name, bank accounts, everything. All of that's put together, and then we have the gross estate. Creditors have 6 months from date of appointment. Beg my pardon. They have 6 months from date of death to file claims. Now, some people think if they wait until after someone dies 6 months, that's going to take care of it. But creditors can file immediately after death. And we have quite a system that takes care of that. And we have a good tickler system that helps us to keep track if the personal representative is doing things timely. We send them reminder notices. 9 months after date of appointment, they have to file an accounting. Hopefully it's the final account, but in some cases, the estate is much too complicated to have your final. But they need to file an accounting, and then 6 months after that, they follow up with another accounting. And that's how we keep track of it. And when all the bills are paid, all the issues are resolved, then we can distribute. And that is presented to us. My office is responsible for the administration of all of that. We audit the accounts, and then the court needs to approve that final account. Some of you will wonder what the orphans court does. They are a court that resolve issues. If people are disagreeing with something in the will, or they're disagreeing with something on the accounting, that's taken into the court. But if an estate moves smoothly, the court won't even know there's an estate in there until it's time to close it. Any issues that come up are sent over, then they know. But we handle all the administration of the estates. I think we can take some questions now.
Okay, we'll take a few because we're running up against the clock. Inez Claggett, and then the lady in the blue in the back, and the lady in orange.
As far as your estate, what if you have an estranged child that you have written out of your will and you pass away? Does your estranged child have a right to, one, contest that will and then maybe receive a distribution on it? And then the other scenario is you have an estranged child, you don't have a will. Will that estranged child then have access to your assets?
The question, can everybody hear the question? If you have an estranged child and you have a will and you left them out, or you don't have a will, does that child have a right to come in? And the answer is yes. They do.
In both situations.
In both situations, that's correctly. Now, they would have to caveat the will to come in the first instance. In the second instance, they're already there.
So the child would have to caveat the will. So the child would have to know that the parent or family member was deceased and would have to go to the Register of Wills office to.
Well, not exactly. The question is, the child would have to caveat the will, or the child would have to know that the person was deceased. The personal representative has a fiduciary duty to give us a list of interested persons, and that child has name and address, has to be on that. And we send a notice to all interested persons after it's published in the newspaper. So that child would have gotten a notice. Now, sometimes games are played.
Right.
And that they declare, that the PR declares that they don't know the address. They'll give you the name, but they don't know the address. We now have what we call an affidavit to locate, notify interested persons. And if they say they can't find them, they have to tell us by what means they have tried to find them, and they have to give us quite a complicated list of things that they've done to try to locate that child. So that doesn't happen much.
Who are the interested persons? Is it one generation, your children, or?
Interested persons are people who would have inherited if that person died without a will, which would be children, spouse, grandchildren. If a child dies, then their children become, you go down. Or the legatees named in the will are the interested persons.
Lady in the back.
Hello, thank you. And you might just say, you need a lawyer, stop asking. But okay, so have a bachelor brother-in-law and a sister-in-law who live together. The sister-in-law's a widow, okay? The brother-in-law's never had any kids. He's got legal issues, so they cohabitate together in the house. Basically, everybody has died, and those two are left, except for the younger people, okay? So how do they have to own the property to protect each other? So if the uncle, well, it's not husband, but my uncle dies, my mom can live together. How do we know, like, his half of the house that they own together goes to her? Like, how should it be held? And conversely, if she dies, how does it, because she's the only one with heirs. He has no heirs, none. He's never been married.
This question is almost too complicated for me to repeat. I think my best advice to you, they need to see an attorney.
That's what I was thinking, but, yeah.
Yeah, it would be impossible in this room to give specific advice to every individual. There's so many questions you don't even know to ask.
Yeah, I know.
So,
Okay.
goes
We
Pat-
need to-
Yeah.
Thank you.
The lady in orange.
So what happens, someone has filed a will with you, they die, then another will is found that has the required signatures. They change their mind years later but never filed with you. Which will supersedes?
The most recent will. The question is which wills, if you make another will, the newest will is the will that we use. We will file the older one and we will just stamp it, see later will.
Is there a requirement to file a will with you before you die?
The question is there a requirement to file a will with me before you die? No. We provide the safekeeping service because it's centrally located and it's normally the place where most people would look if they didn't know. But you do not. You can keep it in your safe deposit box. Maryland does not seal safe deposit boxes. And if you don't have anyone on your safe deposit box, the register, we can do a limited order, and the register can go in that box to search for the will. Or if you have it at home, someone needs to bring it in.
This gentleman and the lady.
This question may take knowledge of other states, so I'm going to turn it around, okay? Say I wasn't a resident of Maryland, I lived somewhere else, Wisconsin, but I had a small rental property in Maryland, and I pass away. So Maryland has to do a probate. Are they going to do it just on that property or my entire estate?
The domicile controls where you do your estate. If you had an estate in the other state,
Yeah, say it's a rental property in Maryland.
rental property in Maryland, but you died, let's say in Pennsylvania.
Right.
Okay. Did you have an estate in Pennsylvania?
Yeah.
All right. Maryland has a proceeding called Foreign Personal Representative Proceeding, where we will accept the appointment in Pennsylvania. We have reciprocity with Pennsylvania and with most states in the United States, where we accept their appointment. So they send us what they call an exemplified copy of the will and the proceedings to Maryland. We do the foreign personal representative just to clear title to that real estate here.
Margaret, can I get you to explain quickly, so you've been talking about appointments and the process. Can you talk a little bit about the letter of administration?
Okay. The letter of administration is king, for lack of a better word. As a personal representative, you can do nothing without a letter of administration and a seal from my office. You have to establish, a personal representative has to establish a bank account, an estate bank account, and he or she needs a letter of administration. That is the authority that says you have been appointed to take care and manage this estate. You are the fiduciary. You're responsible.
So just by saying it in the will, that's not enough to let you do it?
By saying it in the will, no, it doesn't. And people have come in the office and said, I am this and thus, this is in the will. And I said, I hate to put it this way. A will is only a paper writing until we say it's okay. We have to prove, we look at it and be sure the signatures are right. There's no markings on it, because then it has to go to the court for judicial. Once it's okay, you file the paperwork and we say everything is okay, and we issue letters of administration. Now you're in business to proceed. Thank you.
That's how you get, somebody had asked about how do I get to the bank account when I don't have the power of attorney. That letter of administration you then take to all of the banks that the deceased person had an account, and they will close that account, and you're required to open up an estate of so-and-so, and those funds get transferred into the account. Now you're in business with their money.
We're going to take a question from this lady and these two people over here, because they've never gotten asked a question.
This is kind of like the state-to-state reciprocity. Let's say you registered your will here in Calvert County, and you moved to Michigan, and you're going to stay in Michigan, and you say you never give the original will. Would you have to, before death now, would you get a copy from Maryland and then register it in Flint, or what would you do? What could you do?
Did everybody hear that question?
No, repeat it.
Okay. If you have a will here in Maryland and you move to Michigan, then what happens is basically, if you are going to move to Michigan, I would recommend you take your will with you.
But let's say it's already filed.
But you have the right to come in and take it out.
But you said
Only
you.
you. Only you.
Oh, before, while you're still alive, you still.
Right. Only you. If you file, don't send your husband in to get it, because they're not going to give it to him unless he has a letter from you.
Okay.
I mean, we have to be that way.
Yes.
I mean, I had a circuit court judge years ago come down to me, and he had a letter from somebody that wanted him to change her will, and he said he wanted to draw her will up, and I said, Judge, I can't let you have that will. I've got to have a letter from her. And I mean, it's that you have to do that, because if people are mad at each other, husband and wife, one could come in and take the other one's will out. So you have to have controls.
So we have a question over here.
If you have a will and you don't want it to be changed, not unless it was okayed by 3 other people, is that legal or not? In other words, you have a will and say this will cannot be changed, not unless all these other 3 agree to it. Because sometimes, like you say, you get sick or get old senile. Someone may say, well, let's write a new will for you. Well, then they can put that in their, other words, it will supersede the will you have, right? You said the last will is
the newest will. Okay, the question is, if you have a will, and say you get sick, and you have 2 or 3 people that manufacture a will for you, actually is what you're saying.
You're right.
And they're going to then fraudulently sign your name. Any attorney, there is no attorney I know that would draw a will for someone like that. I just can't envision that happening. I'll be quite honest.
What I could say is, yes, I meet, if I'm going to draft a will for somebody or change a will for somebody, I'm gonna meet that person. Now, I can only do so much to determine if a person is competent. And I will tell you that competency is a very low threshold. It doesn't take a lot to be considered competent to manage your own affairs. So, you know, what will then happen is there's the later litigation comes about when the heirs, and we mentioned caveating earlier, so when that will goes through probate and the interested persons become aware, wait a minute, I don't think this is what Mom wanted. You know, Johnny's getting everything. He clearly committed fraud. Well, then there's going to be litigation in the orphans court trying to show that that person actually wasn't competent, and it's difficult, but that's where that's going to happen. I think your question is, can I prevent that from happening by putting a writing in my will? No. So you're not going to be able to say, this is my will today, and I don't want me to be able to change it 3 years down the road unless 3 people say so.
Yeah, but here's what she said before. The person who makes the will can take it out, but that's the only one. So if you put those other 3 people on there, when someone tries to administrate another will, then you didn't take it out, so wouldn't that work?
Well, so you don't remember, you don't always have to take the will out to make another will.
What if one child comes and says he's incompetent, but I got him to sign this and not tell the other children, but just that one child can do that?
Only the person making the will can change their will. So the question is, I can convince a lawyer that I have the power to change the will. It's not going to happen. Does that make sense?
Yeah, in other words, like you said, my will is, say, registered. Nobody else can come in later on and say, well, he and just got it notarized. That's all they've done. It has to be registered.
It doesn't have to be registered. It has to be prepared with the thank you, attestations, where everybody sees the person sign it and says, yes, they're competent. They can change the will. They want to change the will. I have enough being told to me from the person changing the will, not the children saying, oh, I know Mom wants this. Does that clarify it for you? It's a tricky situation. I can't, you know, we're not going to be able to protect it.
All right, we're going to take one more because we're kind of running over.
Okay, so I'm based on my personal experience, a relative of mine who is much older went ahead and typed up their own will and had somebody notarize it. Is that sufficient?
If somebody notarizes a will with no other witnesses, our saying is that's death to the will.
Okay, all right, so if they had 2 other people, Bob Smith and Tammy Doe, sign that as a witness and it was notarized, would that validate that will?
The 2 witnesses would have to come in and verify that they had signed it and that he was okay.
Okay, so these cannot be fictitious individuals. Okay.
No, they cannot. They cannot be fictitious.
And obviously the older person would actually have to sign it, and therefore you would have to validate the signature of that person.
And a power of attorney can't change a will.
Okay, correct, but I'm talking about the will itself. There is no mention of a power of attorney, but the will itself saying, you know, Bobby Smith from, I don't know, gets everything, and everybody else is excluded. And I don't know if that's the same situation. Somebody can come in and just say, well, this is the new, most current will. If there is 2 witnesses.
If it's 2 witnesses, it will be considered, but it will be, witnesses have to come in.
Okay.
But the reason why I mentioned the power of attorney is that it had come up a little bit earlier, and I just wanted to put
Yes.
that in before we ended, that if you have a power of attorney, they can't change it for you.
You know, I hope you won't take offense at this, but I tell people, if a person has a power of attorney, it ceases at death, and I know people have used them after death, I say you might as well put it in the casket. Now, that sounds almost crude, and I apologize, but it's that final. It's that final.
We do have one more from Ms. J.C., one of our former commissioners.
I just wanted to, this is kind of like another side of what you said in real estate, and a lot of people don't realize it. I just want to kind of give 2 examples, because being in real estate, we had a marriage, he was married, divorced, his first wife died, then he got married to the second wife. They put off getting her name put on the deed. He eventually died, and so it went to her, but he had children from the previous marriage and one with her. And at this particular point, she's getting ready to try to go to a nursing home, was going to sell the property, and boom, because he'd been past 10 years, one of the other children decided to open up probate and to contest and wanted a part of that. We see this a lot, as you say, the deed superseded, but she never got her name put on the deed, had the old wife's name taken off. So now we're in, and what you're actually saying is if you don't go to probate and take care of this, you're looking at that house being dormant for 9 months or probably longer going through the process. The other side we had was couple divorce. She went on, but they were in mortgage together, so they couldn't do the deed. But in the meantime, he passes away. His side of the family decide that they want a portion of his property. Probate, once again. In both cases, no wills. And this is just, and it's confusing the whole task in your system, because you just identified maybe say 9 months, and we can go into this now for a part of one of the one I told you about is 2 years, and it can go longer. So coming back to what you said, it's very important with your real estate that you make these changes because of the will and the probate. So I just want to kind of say it complicates it if you don't go this particular route and prepare along the way. You're going to have problems in real estate.
Yeah, that's a couple situations there that you're talking about. And there is one example in your file, in your folder, of a divorce, not divorce, the widow marrying a widower and then putting the widower's name on the home. And when the second one died, the home went to his family and left the other one out altogether. It's an example of it in here. Now, the one you were speaking of, they didn't do anything. So yes, according to Maryland law, it goes to his half when, he died. Then she would have, depending on when he died, she would have gotten $15,000, and they would have each gotten a half and a half. But it all depends on, the law changes constantly, and distribution can change. So there's a variation of circumstances in your example. So you do need to be careful, and things need to be handled properly. When someone dies, you need to check to be sure that you clean up all the affairs, not put it off. This county is noted for heir property. And it can create enormous problems. So let's all look at our assets, decide what we're going to do, get our wills in proper order, get our assets all together, and so that when the time comes, you'll be ready and you'll have things in order.
Could we give her a hand? I just want to remind you that we gave you a survey fill those out and drop them at the desk on your way out. But before that, I would like to introduce the women who support and provide things like this to you from the Commission for Women. And, ladies, would you come to the front and identify yourself?
While they're coming forward, there's just one thing. I don't want anybody to misunderstand. I don't accept clients like attorneys do. My office door is always open. I can answer questions to the best of my knowledge and steer you in the direction. So.
And she's good.
Good morning, ladies and gentlemen. My name is Inez Claggett, and I am chair of the Calvert County Commission for Women.
I'm Lisa Zarafino. I am the secretary. I'm Joan Dell Winship, and I am treasurer.
Arian Odom, vice chair.
I'm Brandy Tremel. I'm an associate commissioner. If you have any questions, calvertwomen.org.
And you already met me, I'm Jennifer Dill, I'm also a commissioner, and I just want to thank all of you for coming today. I hope you'll come to our future seminars. Please fill out the survey, it's very important that we get your feedback so that, and we want to know if you want us to continue doing this.
Thank you.
If you don't have a survey form, there are some on the table in the back, and there's a pen and pencil back there. My name is Gloria Della, and if you have any questions, do visit our website, because we have decided that we're going to populate that website with all the things you need to know. And if you can't find us, just go to the Board of County Commissioners, pull down the drop-down menu, and you'll find the Commission for Women. Please have some more of our refreshments in the back. Take some with you if you want to. And thank you again for coming.